Can you accidentally waive legal privilege with inadvertent disclosure? Imagine sharing a secret with a friend and then accidentally telling someone else. That's similar to what happens when privileged information is unintentionally disclosed in court. Legal privilege, like attorney-client privilege, keeps certain conversations private between a client and their lawyer. It's a shield that stops others from seeing what's discussed. But what if that shield gets broken without meaning to? That's where the question of accidental waiver comes in. When privileged information is shared by mistake, courts look closely at what happened to decide if the privilege is lost. Inadvertent disclosure happens when privileged documents or communications are shared without the intention to do so. This often occurs during the discovery process, when parties exchange evidence. Sometimes, documents are produced without a thorough review, leading to accidental sharing of protected info. When this occurs, the key issue is whether the privilege has been waived. Usually, if you tell a third person something confidential, you lose the privilege. But courts don't always see accidental disclosures as an automatic waiver. They use a reasonableness test to decide. This test asks if the disclosure was truly accidental and if the party took proper steps to prevent it. It also considers whether the party acted quickly to fix the mistake once they realized it. For example, if a lawyer notices a privileged document was sent out by mistake, they should notify the other side immediately and ask for the document back. Courts also look at whether the disclosing party had safeguards in place, like reviewing documents carefully before sharing. Federal Rule of Evidence number 502 guides courts on this issue. It states that inadvertent disclosure does not automatically waive privilege if the disclosing party took reasonable steps to prevent the mistake and acted promptly to correct it. Different courts may interpret these rules differently. Some might say any disclosure waives privilege, no matter what. Others focus on whether the disclosing party was careful and acted quickly. In real courtroom situations, lawyers must be very careful with sensitive documents. They should review everything thoroughly before sharing and have policies to prevent accidental disclosures. If a mistake happens, acting fast is essential. Courts will consider how much was disclosed, what kind of information it was, and whether justice is served by keeping or losing the privilege. It is also important to know that work product protection, which covers materials prepared in anticipation of litigation, is different. Usually, disclosing work product only waives protection if it makes it easier for an adversary to get the materials. Sharing with a legal team that has the same interest often does not waive this protection. In summary, yes, you can accidentally waive legal privilege through inadvertent disclosure. But whether that happens depends on how the disclosure occurred, what precautions were taken, and how quickly the mistake was addressed. Courts want to see that parties acted reasonably and responsibly to protect sensitive information. Staying vigilant and acting swiftly can help keep your privileged communications safe, even if a slip-up occurs.